So I ask that I'm afforded some patience. This case is a misdemeanor DUI with a Vikash Patel. He was backing off of a road, ran into a ditch. Police were called. The police suspected that he had been drinking, and then there's several details about that, only two of which are our concern here today. We are asking this court to reverse and grant a new trial on the BAC results having been entered into the chain of custody, or without proper authentication as to chain of custody. Officer Sasser did, Officer Sasser did testify at court that he had witnessed Mr. Patel have his blood taken, and that he himself deposited the blood sample into the evidence locker at Greenville Police Department. Defense counsel properly objected to the omission of BAC on authentication and chain of custody grounds. However, there was no testimony regarding who had possession between the time at which Officer Sasser had deposited the sample and at the time which Agent Carlisle at the TBI had tested the sample.
Is that link in the chain required?
Well, not every single link in the chain is required, Your Honor.
I mean, how do you distinguish State versus Singh, for example?
State versus who, I'm sorry?
Singh, S-I-N-G-H, reported case from this court from 2023.
Well, Your Honor, I apologize. I'm not familiar with
That's okay.
State v. Singh.
Let me tell you what I think Singh says, and then tell me how your case may differ. I think that Raghu Singh's case says that you have a chain of custody where you have the officer observe the blood being taken, where the officer essentially places it in the box or takes custody of the box from the phlebotomist, puts it into an evidence locker. A TBI agent then testifies that that box has been received and that there's no evidence of any tampering and everything essentially looks fine. And in Singh, I think, laying it out in a bullet point list, said that's sufficient chain of custody. You can argue about it to the jury if you'd like, but that's sufficient for admission. If that's what Singh is saying, and just assume that's maybe for this question, if that's what Singh is saying, how does your case fit outside of Singh? Seems to be dispositive.
At first glance, Your Honor, I think it does. There are several cases in recent years from this court and the Tennessee Supreme Court that deal with this sort of issue.
And Singh tried to summarize them all and put them into a bullet point list.
Yes, Your Honor. And it seems, may I ask, in Singh, is there any testimony as to how it was transported at all?
No.
You're saying that the only one? Okay.
But that link in the chain was completely missing.
Well, our argument would be based that while any one link can be completely missing, that there needs to be enough links to establish that there was a sufficient authentication that what is being tested is what it purports to be. Our whole argument here is that those two are not enough. If Your Honor is saying that Singh identically matches that, then I would concede that, but I would still argue that those two links logically to me don't seem to be enough. There's no way to know that, other than the fact that that's how it's typically done, and that there seems to be no tampering. There's no way to know that there hasn't been anything happen with it. We don't even know who or what service transported, who pulled it out. Further, to support our side of the case, we would also add that at the trial court, no logs were introduced as to when evidence was taken from the Greenville Police Department crime lab or evidence lab. No logs were presented on evidence, just testified to about the TBI drop box. And that testimony only included how it usually is done and what the process is for her to receive, Agent Carlisle, that is, to receive the samples. Further, Agent Carlisle of the TBI testified that she received some 500 samples a month, I believe, without having any testimony as to specific memory of that vial or who brought it to her. we're relying entirely on the fact that the seal was, as she testifies, intact. I think our position is that because there are at least 2 links missing, we would say several more, that this would be a case where there was abuse of discretion regarding authentication. But I'll move on to the next ground that we are arguing today. That would be sufficiency of the evidence to sustain a guilty verdict as charged, or against what's charged in the indictment. The indictment here, unlike most indictments for a misdemeanor DUI, reads, or DUI per se, reads.
The indictment charged DUI per se in only 1 count. It didn't charge DUI generally in another count.
Sorry, Your Honor. Yes, 1 count, Your Honor.
Pardon?
1 count.
One
I think I
count.
misunderstood the question.
So he was only charged with DUI per se that led to the conviction.
Yes, Your Honor, but the wording in the charging instrument was that defendant was driving or operating a motor vehicle while his blood alcohol content was, and it specifically states 0.114%. And then it goes on to say an amount greater than 0.08. But
Is that language surplusage in the indictment?
I would argue that it rises past surplusage to variance in the indictment, Your Honor.
Well, it's not a variance. I mean, a variance would be a variance with the proof at trial. I'm just talking about just the allegation of the indictment. So is the recitation of the specific blood alcohol content in the indictment, is that just surplus language?
I mean, surplusage and variance, from what I've seen, can sort of overlap, but yes, you could call it surplusage.
Well, let me ask maybe a more basic question. If it is surplus language, can the surplus language enlarge the essential elements that the state must prove?
I understand what you're asking, Your Honor, because there is obviously case law that states that an additional element is.
There's a reported case from Judge Witt here in 2008, State versus March, Perry March's case, where
Yes,
this
Your
court
Honor.
holds that surplusage can't enlarge the essential elements of an offense.
Yes, and State v. March does deal with the indictment, but here we're dealing
As this
with
does.
more than just the definition and surplusage. It is charged in the indictment as specifically that he was driving while his alcohol content was at 0.114, and the jury instructions were instructed to match that. I don't think that this would just be surplusage or definitions. The way the indictment is charged, it does not say or an amount, or that he was driving at an amount greater than 0.08. It says he was driving or operating a motor vehicle at an amount of 0.114, and then as a descriptive, it goes on about the amount being greater than 0.08. And on that ground, we don't believe that there was any rational basis for which the jury could find a conviction that on the ground that he was driving at the specific time right before the police came with an alcohol content of 0.114 when his blood was taken sometime later. Now, Agent Carlisle testified that there was no way to know what Mr. Patel's specific blood alcohol content was at any time before or after the sample taken. And with the sufficiency of the evidence, whether any rational trier of fact could find the evidence proves elements beyond a reasonable doubt and light most favorable to the state. Excuse me. Again, the light most favorable to the state is that he took a blood sample and that it tested as 0.114. That doesn't get around the specific language in the indictment that charges the jury with finding beyond a reasonable doubt that Mr. Patel had been driving while his blood alcohol content was specifically 0.114. The jury had no rational ground upon which to convict under any legitimate view or inference because the state's witness's own testimony couldn't furnish an opinion as to what the BAC was during operation as required by the indictment.
So, Mr. Knight, can I ask you maybe a more fundamental question about the appeal? Was the notice of appeal untimely?
The notice of appeal, Your Honor, I see where the state claimed that it was untimely.
If I'm looking solely at what's in the appellate record, how do I conclude that you have a timely notice of appeal?
Well, Your Honor, we, in reviewing the court record, which is a part of the appellate record at the trial court, there is still no officially stamped judgment or order overruling the motion for a new trial from which our time to file a notice of appeal would begin. And so if we're going by the way, the standard operating procedure, then technically we still just shouldn't even be here today on that ground.
Under that, because there's no file stamped order in the file,
Right.
your position is that even if you filed a notice of appeal today, it would still be timely?
That it would be timely, yes, Your Honor.
Okay.
And
There's nothing else in the appellate record, though, that would suggest, I think there was a reference to the court minutes, but the court minutes aren't here in the appellate record, are they?
the court minutes are not here in the appellate record, but that would be on the state's burden, I believe, to try to prove that it was untimely. If
Is
there-
it, or is it your burden to
Our burden is to file it timely, Your Honor, and
establish that there's been a timely filing?
our position is that we did file timely, yes, Your Honor.
Okay.
If there are no further questions, I will yield my remaining time to the state. Thank you, Your Honors.
General, what about the notice of appeal? I mean, typically, we look for a file stamped court order, and the motion for new trial denial doesn't appear to have a file stamp on it, although the other documents with it do. So what do we make of that?
So, Your Honor, I think it's not entirely clear from the appellate record. I have not seen anything in the trial record, so to the extent that the defendant is citing to anything not included in the trial, or in the appellate record, I don't think this court can consider that.
Sure, I agree, but let's assume that you only have a order denying a motion for new trial that has not been file stamped with the clerk, or hasn't been filed with the clerk with a file stamp. I mean, that's what we have to have, right, to start the clock running?
Correct. So I
Okay,
think
so it's not untimely?
in that instance, it probably wouldn't be untimely,
Okay,
correct?
That's fine.
But again, it's not entirely clear from the record what exactly all of the timing is and when everything was denied. Based on the oral denial of the motion for new trial, it would have been untimely, but if there wasn't a file stamped copy entered, then I think that's a different scenario.
That's
But
good.
yes.
Okay. Thank you.
Before you go any further, I meant to have mentioned to you my concern about the absence of the motion for new trial in the record. Even though the order the trial court entered addresses the fact that there was a motion and mentions the issues raised, there is a significant jurisdictional impact with motions for new trial in terms of appeal, and it may be fine as is, but if I were in your shoes, I would seek to supplement the record with motion for new trial.
Your Honor, if I may address that briefly, I do think that his motion for new trial was in the record.
Pardon?
I believe his motion for new trial is in the record on page 16.
But your brief says it wasn't.
On page 16 and 17. I apologize if that was unclear in my brief. The order denying it was not in the record. The actual motion, I believe, was in the record on page 16
Well, I
and
understood it to be the
17.
other way around. The order overruling the motion is not in the record?
So there's, his motion is in the record, and then there's the motion for new trial hearing that's in the record, and the court orally denied it, and then there's some court paperwork where there's like a handwritten note on the paperwork saying that the motion was denied. But his actual motion is in the record, I believe, as far as I'm aware. So this court should have jurisdiction as far as the motion for new trial being present in the record on appeal. And I would defer to the record on that, but I believe it's on page 16 and 17 of volume 1 of the record. in the technical record.
Well, I tell you what, counsel for appellant needs to take a look at this and make sure that we're in good order in terms of the timely filing of a motion for new trial and the overruling of it, and how that reflects upon the filing of the notice of appeal. I'm not suggesting there's a problem here, but the issue has come up, and I suggest you take a look at that. And if you feel like a supplement of the record needs to be done, then you need to do that. All right.
May it please the court, Abigail Renard for the state. This court should affirm the defendant's conviction for DUI per se. The state established a sufficient chain of custody for the blood kit, and the evidence showed that the defendant was driving while his blood alcohol content exceeded 0.8%, and the defendant is not entitled to relief here. First, turning to the chain of custody issue, the state's proof reasonably established the identity and integrity of the evidence. Judge Greenholtz, as you aptly noted, the Singh case is controlling here. The state is not required to prove chain of custody beyond a reasonable doubt or even establish every link in the chain of custody. And here, this court has found in almost nearly identical circumstances repeatedly that chain of custody can be based solely on the arresting officer's testimony and testimony from the TBI agent.
I mean, are the facts here materially different from Singh's case?
I do not believe so, Your Honor.
They look to be pretty close to me.
I think they're nearly identical. So here, the officer testified that he watched the nurse draw the blood. He saw her sign the paperwork, seal the blood kit, sign it. He watched the entire procedure and never saw anyone testify or anyone tamper with the kit. He then took it to the police department, where he immediately placed it in the evidence locker, where only the evidence detective had access to it. The TBI agent then testified that the kit was hand-delivered to the TBI's blood alcohol drop box, which she described as being similar to a blue mailbox where you can put your mail in, but you can't get it back out. And at that point, only the forensic technicians have keys to it and have access to the blood kits. When they empty the box, the forensic technicians put the blood in the fridge, they open and inventory the kit, they photograph everything, assign case numbers, and document any irregularities that come up. And the defendant's kit here had no notation of irregularities, and there was no indication that anything had gone wrong. There was just nothing in the paperwork showing anything. And this court has held repeatedly that this is sufficient to establish chain of custody, and those cases are dispositive of this issue. And to the extent the defendant relies on State v. Gibson, in that case, it's very distinguishable because the arresting officer there testified that he gave it to someone, but he couldn't remember who. He didn't know who he gave it to, what happened to it. I think his testimony was something along the lines of, oh, once I give it off to this person, then I don't have anything to do with it. And this court in Gibson distinguished from other cases where the arresting officer had placed it in the evidence locker. And so here, this is a case where it was placed in the evidence locker, not where the arresting officer gave it to someone random who he didn't know who it was. Turning next to the sufficiency of the evidence, here the evidence showed that the defendant was driving a car on a public road while his blood alcohol content exceeded 0.8%. That evidence is sufficient, and that is all that the state was required to prove. The defendant's arguments about the indictment, although creative, have no bearing on this court's sufficiency analysis. The statute requires the state to prove that he was driving on a public road while his blood alcohol content exceeded 0.8%. My understanding of the defendant's argument is that he's not contesting really any of the statutory elements, and has conceded that the state proved what's required by the statute. His only claim is really that the indictment language, including the 0.114%, requires this additional proof. But again, to your point, Judge Greenholtz, that any extra language in the indictment in that way is really just surplusage. It doesn't change the impact of sufficiency analysis, and it doesn't really have any impact, particularly here, had The defendant hasn't raised any sort of challenge to the indictment. Even if he had, the indictment includes the statutory cite to DUI per se. So there's really no way to get around that the state proved the elements that are required, and the defendant has conceded that the state proved those elements.
I thought the argument was a little more refined than that. What I took from Mr. Knight was there was maybe some issue with the indictment, maybe not, but the real issue is with the jury instructions. And so the trial court instructed the jury that it must find that he was driving when he had a blood alcohol content of 0.114, and that because the trial court instructed the jury that it must find that as part of the elements of DUI, that the jury had to find it beyond a reasonable doubt. What's the state's response?
That is not the argument that I took from the defendant's brief. So to the extent that that argument differs at all from what he made in his brief, the state's position would be that it's waived at this point. He couched his argument as a sufficiency of the evidence, not as a challenge to the jury instructions, not as a challenge to the indictment. So I think, at the base, this is a sufficiency of the evidence analysis and a sufficiency challenge. And viewed in the light most favorable to the state, again, I would say the state proved all of those elements. To the extent that this court disagrees and thinks that maybe there is a more nuanced jury instruction issue,
I think essentially what they're saying is that the trial court added an element, and because the trial court added the element, the jury was under an obligation to find it.
So in that instance, I think it's the same as with the indictment, where that's surplusage. It doesn't change this court's sufficiency of the evidence analysis. At the end of the day, the state is required to prove the elements of the offense, and the state did. And whether there's a slight difference in the jury instructions and in the indictment, it's the same kind of surplusage analysis, or not analysis, but the same kind of surplusage language, where the state, it's not an additional element that has to be proven. And if this court has no additional questions, we ask that you affirm. Thank you.
All right, thank you, Your Honors. With regard to the first issue that we've raised, which is the error associated with the admission of the blood alcohol results, the State versus Singh case, Judge Greenholz is correct. There is sort of a bullet list that, when you look at the facts of this case.
It's a very helpful bullet point list, right?
Do what, Your Honor?
It's a very helpful bullet point list, right?
Yes.
Yes, okay.
Well, in understanding what that ruling is, it is certainly persuasive authority from the Court of Criminal Appeals out in Jackson, I believe.
It's binding authority, right, because it's published?
Well, I didn't get that far. I was skipping ahead to the bullet points if I could.
And the Supreme Court denied review?
I didn't get that far either. I just wanted to make sure I could keep up with
That's
what
okay.
they found. And that was, of course, the facts and what that Singh case finds is very similar to this case. However, in that case, the officer did not place the blood vial in a box. He handed it to a supervisor who apparently placed it in a box, which is strange that they had that bullet point list and then the facts are different than what the bullet points they say are sufficient. Anyway, and looking at Singh, and then, of course, Gibson, which is another DUI case that we cited in our brief, there's at least two links in the chain that are missing. I mean, we have Rule 901 and we have the rulings in Cannon and Gibson that are, we have to authenticate things. Before they can be admitted in court, somebody has to say it is what they propose it is. So here, we have two that we know of missing links in the chain, which is the evidence detective that Officer Sasser talks about at the trial. What happened after he left it in the evidence locker at the Greenville Police Department, quote, he doesn't know. Well, we don't know either, because we don't know how it was delivered to the TBI in Knoxville. We don't know whether it was carried by a detective. We don't know whether it was by some common carrier, as Agent Carlisle testified, UPS, FedEx, whoever. We don't know who the technician is that retrieved it from the box at the TBI. All we know is whenever that objection was made by counsel at the trial, and the trial court brought that to the state's attention that they had a pretty serious issue there, they recalled Officer Sasser, who then testified, I saw the blood being drawn and went through that procedure, but we still don't have at least 2 missing links in the chain, and the technician of the TBI, the forensic expert, she also testified that they analyze about 500 samples a month. So plenty of opportunities for there to be questions about the authenticity of these test results. All we want is to know that it's the actual sample here, and seeing maybe binding authority, but it seems to be eroding away some due process concerns that defendants should probably have. So moving on with the sufficiency of the evidence claim. We don't concede that they proved it was .08, all right? The indictment is a big problem for the state. Strategically, a defense lawyer may not want to bring up too many issues with the indictment that can be fixed pre-trial. So the indictment alleges that he operated a motor vehicle on the public roads of Tennessee while his blood alcohol content was 0.114%. We proceeded through the voir dire, making sure that we made the jury aware that the state was going to have to prove that, sort of testing the waters on how the state was going to react. That was the moment the state reacted, that realized that they had a problem. You can infer that from the record there. And the court later on said, hey, I'm going to instruct the jury that they must find 0.114 was his BAC at the time he was operating a vehicle. We don't know what time he was operating a vehicle. We don't know when the last time he was behind the wheel, and we don't know what his BAC was at that time. Agent Carlisle testified, I cannot say what his BAC was at any time before or after the time of that blood draw. Therefore, it is impossible that the state proved beyond a reasonable doubt, in the light most favorable to the state, that his BAC was 0.114 when he was behind the wheel of the car, and therefore the evidence is insufficient, and we ask for judgment of acquittal. And on the other issue, we ask respectfully for not successful on the sufficiency, for a new trial that adheres to the requirements of authentication. Unless there's any further questions, I'm out of time. Thank you. And I looked for my blazer this morning and couldn't find it, so go Vols.
All right, thank you. Thank you, everyone, for your argument in this case today. Court will be in recess until 1:30, please.